Welcome to Epstein Becker Green's Employment Law This Week podcast. I'm George Whipple. Many workplaces are experiencing tension in the wake of the tragedy in Utah, most notably involving employee conduct on social media. Epstein Becker Green's Kim Carter is here to help employers who are fielding complaints, demands to terminate employees based on their social media posts, or are generally concerned about employee conduct.
Absent the existence of an employment agreement or collective bargaining agreement that lays out specific conditions for termination of employment or disciplinary action, most workers are at-will employees, meaning an employer can terminate the employee for almost any reason or even no reason at all, as long as the reason doesn't violate the law. As such, employers are given wide latitude to terminate employees for their conduct at work, as well as conduct outside of work hours. Some states have passed laws to protect employees' rights to engage in lawful off-duty activity. However, these laws don't provide employees with complete protection for all off-duty conduct. For example, employee conduct that could harm the reputation of the employer may serve as a valid basis upon which an employer may rely to discipline its employee.
In general, there is no protection for an employee's public speech or behavior, including on publicly accessible social media accounts.
However, employers generally have the right to monitor employee activity on company-owned devices and networks on or off the clock. Employers are additionally permitted to view its employees' social media posts and online activity that are publicly available and take employment action based on the content of the employee's activity, so long as there is no statutory prohibition to do so.
While employers have broad latitude in this area, it's important to remember that employee discipline always comes with some risk. Establishing clear policies ahead of time is key to mitigating that risk.
In addition to creating and updating its EEO, anti-harassment, anti-discrimination, and technology use policies addressing employee conduct generally, an employer should consider issuing a code of conduct policy that clearly outlines the employer's expectations related to employee behavior and professional standards, both on and off the job. It's also recommended that employers develop social media policies that clearly outline expectations regarding how employees should conduct themselves online during work hours and during their personal time, including a discussion that sets forth the consequences if an employee fails to abide by said policies, up to and including termination, if that's the case.
Thanks, Kim. Thanks for listening. We'll see you next time.
This podcast is presented by Epstein Becker Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.